Hey everybody, News Now Wyoming, bringing you another episode. This time we're going to be talking about malicious prosecution. We're going to end this series right here. The Supreme Court, or we're going to end it for now until after the Supreme Court makes a ruling. We may even watch the arguments or listen to the arguments and do a reaction video to it. So the Supreme Court is to decide malicious prosecution case. In Heck, the U.S. Supreme Court held that a plaintiff can't bring a civil suit for wrongful conviction unless his or her conviction was favorably terminated. But what if charges were dropped and the plaintiff was never convicted? In Thompson v. Clark, the Supreme Court will decide when a plaintiff who was charged but never prosecuted may bring a malicious prosecution case. The court will also decide whether in a civil case the plaintiff or defendant must prove an exception to the warrant requirement justified a search. Larry Thompson's sister-in-law, who was living with him, reported to 911 that Thompson was sexually abusing his weak old daughter. Thompson wouldn't let police into his apartment because they didn't have a warrant, blocked their path to entry, and allegedly shoved an officer. Camille's report was false. She suffered from a mental illness that the officers sensed when they were in the apartment. Police arrested Thompson. He was charged with obstructing governmental administration and resisting arrest. The prosecutor dropped charges against him in the interest of justice. Thompson brought a number of civil claims against police, including malicious prosecution and unlawful entry into his house. The Second Circuit held that Thompson couldn't bring a malicious prosecution claim because he failed to prove that the prosecution against him terminated favorably. And again, you guys, that's my argument, is if you're never charged, then then the cop, that could be a malicious prosecution. Not always, but it could be. In 2018, the Second Circuit held that malicious prosecution claims require affirmative indications of innocence to establish favorable termination. In this case, Thompson's innocence wasn't established because the only reason the prosecutor gave for dismissing charges against him was in the interests of justice. The officer sued in this case defended the Second Circuit ruling, stating courts have long set a high bar for malicious prosecution claims, recognizing that our criminal justice system works best when people feel free to come forward with accusations for the protection of victims and the general public, a step that sets in motion a panoply of procedural protections designed to fairly adjudicate guilt. So all the federal courts of appeals but one to consider this issue have ruled the same as the Second Circuit. According to the 11th Circuit, favorable termination occurs when proceedings end in a manner that affirmatively indicates innocence. Thompson urges the Supreme Court to adopt the 11th Circuit rule. He points out that in Heck, all a plaintiff had to do was show favorable termination in order to challenge a conviction was to prove the judgment against him or her was invalidated, not that he or she was innocent. The Fourth Amendment generally requires police officers to have a warrant to enter a person's home, unless an exception applies. The police officers in this case claimed exigent circumstances justified their warrantless entry. The jury ruled against Thompson's claim the officers violated the Fourth Amendment in this case. Thompson argues that the defendant police officers in this case should have the burden of proving that the exigency existed, just like they would in a criminal case. The Second Circuit disagreed, holding that Thompson had the burden of proving that exigency didn't exist. The Second Circuit relied on a 1991 Second Circuit case. In that case, the court held the burden of proof for whether a Fourth Amendment exception applies in a civil case is with the plaintiff, because the burden of proof generally rests with the plaintiff in civil cases. And honestly, guys, that's not a bad argument. I can get behind that argument. However, if I, as the plaintiff, say you had no exigent circumstances, you've got to prove that wrong. I mean, how do I prove it in the negative? How do I prove a negative? That you didn't have exigent circumstances, that what you thought was exigent circumstances were not exigent. Again, we're talking about looping circles, right? Putting everything in circles and going around and around and around. The officers, by their own admission, admit that yes, something about the witness appeared to be wonky. We're going to take her reporting as factual. So, and in this case, the guy was all charges against him were dismissed. No charges were brought up for the entire reason that they were there to begin with. He wasn't arrested for abusing his child. He was arrested for what was that? Obstruction of administration and governmental administration and resisting arrest. So, them dropping the charge against him in the interest of justice, that should be a favorable outcome. So if we go to the SCOTUS blog here and look at the filings on this, we see the petition and then motion to extend, etc. So here's the brief amici, couple different brief amicis, which are front of the court type of things. Briefs go with it. Brief of respondent. So it took them, what is that, 3 months? Yeah, 3 months or so to actually respond. Silly officers. Reply, and then 6 days later they had the reply of the petitioner, and then joint appendix filed. So brief of petitioner Larry Thompson, and then all these friends of the court filings here. So both sides, or multiple people on every side of this, has actually come out and said, yes, this is why we agree, this is why we disagree. So lots of case law, or not lots of case law, but lots of arguments on this right here. So it is going to be a very interesting argument set for Monday, November 1st. And then another brief by the police officer. And then the U.S. government to participate in oral argument and for divided argument. I actually want to look at that. Hold on. Let us pull that up. And on writ of certiorari to the United States Court of Appeals for the Second Circuit, the acting Solicitor General on behalf of the United States respectively moves that the United States be granted leave to participate in the oral argument in this case. And normally they are just granted it. The petitioner has agreed to cede 10 minutes of argument time to the United States and therefore consents to this motion. The question presented in this case concerns the requirements to establish a claim under 1983 against local law enforcement officers based on an alleged unreasonable seizure to legal process in violation of the Fourth Amendment. Court of Appeals held that to establish such a claim, the plaintiff must prove that the underlying criminal proceedings initiated by the legal process is terminated in a manner that affirmatively indicates the Section 1983 plaintiff's innocence. The United States has filed a brief as amici curiae supporting petitioner, contending that the Section 1983 plaintiff should be required to show that the underlying criminal proceeding has terminated in his favor, but not that it's terminated in a way that affirmatively indicates his innocence. So that's again, and God, I hate to agree with this, our current Attorney General, but that's my entire argument. That he right there in one sentence, that it be terminated in a way that affirmatively indicate that he not be required to prove that. The United States has a substantial interest in the issues presented in this case. The U.S. is committed to ensuring that constitutional rights are carefully safeguarded. The government prosecutes individuals, mostly state and local law enforcement officers, who willingly violate individuals' rights under color of law in violations of U.S.C. 241 and 242. And the government brings civil actions against state and local law enforcement actions under 34 U.S.C. 12601, which authorizes the Attorney General to seek appropriate relief to remedy a pattern or practice of law enforcement officers' violations of constitutional rights. In addition, this court has often invoked its Section 1983 jurisprudence in cases involving implied causes of actions against federal officers for the deprivation of constitutional rights. In Bivens, right? Now that's a big one. The United States, therefore, has substantial interest in the circumstances in which federal officers may be held liable for damages in civil actions for alleged violations of constitutional rights, to the extent that such a claim remains viable after Ziegler. The government has previously presented oral arguments as amicus curiae in cases concerning the contours of constitutional tort claims. As in those cases, we believe that participation by the United States in the oral argument of this case would be of material assistance to the court. And then Acting Solicitor General, Counselor of Record. So there we go, you guys. It's a rare day. I'm going to agree with the U.S. Attorney General, Acting Attorney General. There we go. What do you think? What should be the outcome in 2022? What do you think about the case? Is it a strong one? We haven't really looked at the motions. I'm going to dig through them some more. I did read a couple of the filings yesterday. I did miss the one about the government actually taking part, but that was just filed, I guess, 5 days ago. And I don't know how I missed it, but I did. So there we go. Thank you guys for joining, and have a fantastic rest of your day. Make sure you hit that like, subscribe, and leave me a comment. Let me know what you think. All right, have a good one.